Thank you very much for this invitation. I'm really delighted to be with you today. Just to start with, a few words about my organization and my mandate. The Organization for Security and Cooperation in Europe comprises 56 participating states. In our jargon, we say from Vancouver to Vladivostok, which means United States and Canada, the whole Europe, and the whole former Soviet Union area, including the Central Asian republics. So it's a huge geopolitical area. What my mandate implies that I cooperate with participating states, which means governments, but also, as the Minister kindly said, also parliaments, the judiciary, the civil society organizations, to improve, to achieve better results in the fight against trafficking in human beings. At the moment, Ireland has the chairmanship of the OSCE, and I had the pleasure of paying a country visit earlier this year. I issued a report, which is now with the authorities for their consideration, and will be soon published together with the comments of the government. So this is what I do on a daily basis, trying to push forward our collective action against trafficking in human beings. But first of all, I would like to start with this. What is trafficking in human beings? Because we are aware that this very complex phenomenon is an evolving human rights violation, which takes different forms. The recent estimates of the International Labour Organization indicate that there are globally 20.9 million people in forced labor and trafficking in human beings. Out of this, and you can imagine this is a biblical, dimension. Around 880,000 are in the European Union only, and 3 million are in an area that more or less is the OSCE area. So we are facing, and this is my first point, a massive phenomenon. And this implies that we should somehow change, shift. At the beginning of the struggle against trafficking in human beings, the common perception was that trafficking was a very limited phenomenon, limited to certain vulnerability profiles, to certain countries of origin and certain countries of destination. Now we are facing a very different situation. We are facing different forms of exploitation, sexual exploitation, but also massively labor exploitation, but also trafficking for the removal of organs. Now we have evidence that these cases exist. For forced criminality, people obliged to commit crimes, forced and organized begging, involving especially children, people with disabilities, with a really multifaceted phenomenon. If we want to focus on labor exploitation, unfortunately, we have to admit that trafficking in human beings is becoming a systemic component of certain areas of certain economic sectors. If we look at agriculture, for example, we find trafficking and forced labor in the picking of the tomatoes in southern Europe, in the picking of berries and mushrooms in the Nordic countries, forestries everywhere, construction everywhere, the touristic industry, and among these sectors, of course, also domestic work. And if you look at these sectors, you immediately find out what are the common features. The common features are that these sectors are non-regulated or poorly regulated. These are sectors in which the labor checks, are very difficult or even impossible in in the vast majority of countries, as in the case of domestic work, and they are performed mostly by migrant workers. And these three elements give us, an idea of what the whole picture is, not because trafficking in human beings is necessarily linked with migration, because there is also internal trafficking, and all the estimates indicated that this is also growing. People can even be enslaved at home in their hometown. And still, if they are victimized, if they are reduced to slavery-like conditions, this is trafficking in human beings. There is a bit of a misunderstanding about the concept of trafficking. Actually, I had I was lucky to be a member of the Italian delegation when the negotiation of the protocol, of the UN protocol, took place. And I remember very well that after a certain period of uncertainty, what was very clear was that, to the negotiators, was the fact that trafficking should be the umbrella, the general concept covering all the forms of new slavery, modern-day slavery. This is what the negotiators tried to achieve, and in fact, if you look at the definition of trafficking in human beings in the protocol, but also in the Council of Europe Convention, and now in the EU directive, because we have to say that the legal standard on trafficking in human beings is very strong. It has been agreed and reconfirmed in all the international instruments dealing with this issue. The definition is very broad. It enables practitioners, law enforcement, prosecutors, and judges, for example, to apply this definition to a variety of cases. Unfortunately, the implementation is still very poor, and we struggle every day. We of course do what we can in terms of, for example, of training. We are committed to organizing training for law enforcement, prosecutors, and judges all over the OSCE region. But there is a problem. There is a problem which is not very much about training, but it is much more about sensitization. What happens in practice? The legal definition of trafficking is, comprises three elements: the action, the means, the legal means, and the purposes. Trafficking is there when there is a combination of these three elements, but the only combination which is really considered a trafficking case in courts is a very particular one, fitting in with, the stereotype of trafficking, what people have in mind, which is transfer plus violence plus, mainly in most of the cases, sexual exploitation. This is what is so far mostly recognized as trafficking. But there is another combination which is typical in cases of trafficking for labor exploitation, which is harboring or receipt, which means receiving the work performance of someone who is enslaved, not necessarily by means of violence, but by means of abuse of a position of vulnerability, debt bondage, for example, for the purpose of labor exploitation. This combination is missing. It's still very rarely acknowledged as a case of trafficking in human beings. And why? And this is the big question we have to ask. We held in Vienna a few weeks ago a conference devoted to the linkage between trafficking and discrimination, something that has not been addressed so far, in terms of analysis. Of course, discrimination is always listed as one of the root causes of trafficking. And we know very well that, for example, the membership in a national minority, in an ethnic minority, the membership in a Roma or Sinti or traveler community is a specific vulnerability factor. Some scholars are endorsing the idea that it is certain communities, such as the Roma community, are so targeted by traffickers, it is so systematic, the enslavement, that trafficking, in these cases, should be considered inherently discriminatory. But apart from that, what we try to raise awareness about is the fact that people are subject to discrimination also during the migration process and when they are in the country of destination. And this is an additional factor of social isolation, of stigmatization, social stigmatization, very often there when the person is exploited, sexually exploited. And discrimination offers also the grammar, the hidden cultural patterns to lead to exploitation and to justify exploitation. There are common sense that are not very often challenged. For example, the fact that a migrant worker is it is normal that a migrant worker is paid less than a national, and this is something which is largely accepted in all the OSCE countries. I can see many examples of this sort. So we have to challenge also this cultural patterns that make exploitation happening and lead to some sort of justification of exploitation. In this context, domestic work is one of the sectors in which exploitation can take place and actually takes place. I would be very clear. I would like to be very clear about this. Domestic servitude, what we call domestic servitude, which means domestic work exacted in slavery-like condition, is a small, very small part of domestic work. Domestic work is a huge reality. In the world, there are 53 million migrant women. Domestic work is still one of the big channels of women's regular migration. The vast majority of domestic workers find a decent job. They can support their families home, which is the reason why very often they leave and they migrate. But unfortunately, since domestic work is underprotected, underregulated, underprotected, and there is a situation of dependency, also due to the fact that the person receives accommodation and food in the household. So this multiple dependency can create a situation of abuse and exploitation in slavery-like conditions. What does it mean in practice? In practice, this means that the person is always at the disposal of the employer, that there are no rests, time devoted to rest, no days off, no salary, because the person is only paid in kind, and the person is even prevented from having any social relationship. Sometimes it is prohibited to talk with people beyond the family, and in these situations, of course, it is very difficult for a person to come forward. This happens on many occasions after years of enslavement. So we can see that domestic work is particularly harmful for people. Some of the people we have met, some of the people who have been treated, for example, by the Ellen Bamber Foundation, with whom we are carrying out research on cases of trafficking amounting to torture and degrading, inhuman and degrading treatment. These victims show the same symptoms as victims of torture, as a consequence of abuse and extreme exploitation going on for years and years. What we can do? I would say that we should adopt, and this is the OEC approach to the fight against prevention and fight against trafficking in human beings, an approach which is human rights based and comprehensive. In other words, it is not only a matter of singling out trafficking as an area in which, of course, robust criminal justice response is needed, and assistance and support for victims is needed. At the same time, we have to work to make prevention effective, which means, in the field of labor exploitation in general and domestic work in particular, to improve labor standards and ensure that these standards are correctly implemented. I look, for example, with interest to the experience here in Ireland of the Labour Inspectorate, and I hope that this can be in the future a leading experience, a good practice that can be replicated, which means that households are not only households, they are workplaces, and we must find a way to carry out checks with all the guarantees and the protections of the case, but appropriate checks are needed. Of course, when a case of trafficking for the purpose of domestic servitude occurs, it is imperative to provide victims with assistance and access to justice and remedies, also through legal counseling at an early stage. Unfortunately, there is the big problem on the undocumented migrants, and the big question mark: are they entitled to have access to justice and remedies? My answer is definitely yes. They must be entitled to have access to remedies. And also from this point of view, I look with great interest to what the Minister mentioned, the outcome of the case that for the moment had not a good conclusion, but could pave the way to a legislative solution allowing all migrant workers to have access to justice and remedies. The criminal justice response, of course, in cases which are very, not only human rights violation, but at the same time very serious crimes, which is the case of enslavement for years of a person in a household, the criminal justice response is needed, must be strengthened, because, as I said, it is still very weak, but the criminal justice response is not the only response. In the field of labor exploitation, also labor law litigation, civil law remedies, out-of-court negotiations, and this should be especially developed for people that cannot have access to normal remedies, and this is the case, unfortunately, of domestic workers enslaved in households of diplomats or persons enjoying diplomatic immunity. We have devoted many thoughts and efforts trying to understand how we can tackle this problem, especially because the OSCE is a diplomatic community, and so we are determined to take responsibility for that. So we are exploring good practices existing in countries where there is a big international community. New York, Vienna, Brussels, and Geneva, of course, are the biggest international communities. In these countries, good practices exist, which, for example, imply that the person, the protocol services in charge for the issuing of the visa or residence permit to domestic workers meet the worker in person without the presence of the employer, that the employer is checked concerning, for example, the payment of the salary through bank transfer, so evidence should be given. The person, the worker is interviewed on a regular basis every year, so that if something goes wrong, the person can come forward and denounce a situation, report a situation of exploitation. And also, I would like to mention the fact that concerning domestic work in general terms, and specifically domestic work in diplomatic households, one important problem is the possibility to change the employer. In some countries, the domestic workers are not allowed to change the employer, and this is one of the cases in which the law, as Bridget Anderson, I quote her, said during the conference on discrimination, the law is not part of the solution, but unfortunately is part of the problem, because if a domestic worker is at the mercy of the employer, because otherwise the only other option is to be repatriated, of course this can lead to really serious forms of exploitation. I think that there is momentum to tackle the problem of domestic servitude, and I go to my conclusions. The ILO Convention on decent work for domestic workers is really, I would say, more than a benchmark. It's really an historical achievement. Not only because, of course, the Convention establishes basic protections for domestic workers, but because it is the first time that the international level domestic work is recognized as a real work. And it is the first time that the ILO labor standards are introduced into the informal economy. So it is really a big step forward. I encourage all the participating states to the OSCE to sign and ratify this convention. But this is not the only new thing. Of course, as has been said, the jurisprudence of the European Court of Human Rights is more and more active in the field of domestic servitude. We had the first case, Cecilia Dan, and now on the 11th of October there is the new case, a new case of domestic servitude. I expect that this judgment will raise, numerous problems, and will be an object, an interesting object of discussion, because the judgment concerns two sisters. One of the sisters was employed full-time in domestic work and not allowed to go to school. And in this case, this was recognized as forced labor and servitude, but not in the case of the second sister, because she was allowed to go to school, although she had to perform domestic work when she went home, and this was detrimental for the results of her studies. But what is important, I think, in this judgment is that this recalls all the jurisprudence of the court, not only in the Siliaden case, which is the most similar because it is a domestic servitude case, but also of the Rantsev case, the case of 2010, which established a wide range of positive obligations on the states to protect not only actual victims of trafficking. In this case, it was a case of sexual exploitation. But as I said, the impact and the scope of the judgment of the court is very, very wide. Also in cases of presumed and potential victims, for example, establishing certain obligations also on the country of origin in relation to a situation of social vulnerability that could lead to trafficking. So the big question is how to identify and implement all the positive protective obligations stemming from the jurisprudence of the European Court of Human Rights. Of course, the key word in this field, I think, is empowerment and non-discrimination. Talking about, of course, all the workers, their rights that should be protected and implemented in every workplace. And, as I said, empowerment through the law, in terms of access to justice and remedies, in terms of possibility for every worker to have their salaries back if they get unpaid, and this is very much the case when trafficking is there. Empowerment in terms of also in terms of legal counseling and representation at an early stage, but it is not. Empowerment is not always not necessarily imply legal means. There is also a big cultural work that should be done, and this is very much about creating culturally and socially speaking an environment which is more friendly and welcoming for all the workers wherever they come from. Thank you.